This is William Keat again, back for the final part of this series on the essentials of the British Constitution, and I think this is actually part 9, so it's the last one. And we're in this one. We're going to do two things. We're going to go through the appendix, which is just a few points at the end of the document that we've been reading through, the Occulted Powers of the British Constitution. So we're going to go through those, and then after that, I'm just going to go and sort of summarise some more general points, give some context to certain aspects of it, and go into some deeper explanation about some things as well. So let's not waste any more time. Let's get straight on with this final section. So here we go. Appendix: Further Distortions and Undermining of the 1215 Constitution. To end, it is perhaps worth mentioning some further methods of subversion to the Constitution. If one can control who serves on a jury, then of course it stands to reason one can alter the potential outcome. Although less of an issue currently, various attempts have been made in the past to pack the jury by controlling who can serve, and worse, who in the country is even qualified to sit on a jury. One act of disqualification, which resulted in a huge proportion of the country losing their right to sit on a jury, was written in statute form, thus unlawful, in the 1689 Bill of Rights. Far from being constitutional, as many believe, the English Bill of Rights was an enemy of the people's liberty and attempted to contradict aspects of Magna Carta. So that is a little bit of a surprise, or will be a surprise to many, I suspect, and quite unsettling for some, I suspect, because the Bill of Rights is often claimed to be by many as a constitutional document. It isn't. It couldn't possibly be, because for the simple reason that it's a statute. It's a piece of legislation. Yes, it's based on the Declaration, but nonetheless it is a piece of legislation, and it also contradicts some absolutely fundamental constitutional principles that were expressed quite correctly in the Magna Carta 1215. And it also contradicts itself as well. It actually invalidates itself as well. So there are actually a number of problems with it, and some people even go as far as to claim that it's actually a treasonous document, and I can see why. Now, if you want to get into that, and I would urge you to do so, the best thing to do is to read the essay, The Tragedy and Treason of the 1689 Bill of Rights by Ken Dewdney. It's fantastic and it's downloadable. I've actually put the link there in the document. So do that actually, because it is very interesting and eye-opening. Because what was happening around that time, and we're talking sort of the mid-1600s to the mid-1700s, that was a time where the power of Parliament was being put in place. They were elevating Parliament to a much greater level within our setup, within our governing setup. Because prior to that, under the Constitution more purely, Parliament was not really as powerful. And what they were doing was putting in the foundational structures, if you like, for the political class and the party politics that was to come in the mid-1700s. Of course, that's when it all started, was party politics and majority voting sort of kicked off then. But it was around this time that was the foundation for that. And the Bill of Rights is not the only one. So in 1688, we had the Coronation Oath Act, which you could also claim is treasonous as well, because you don't put into legislation fundamental constitutional customary law. You don't try and create a new version of it in legislation to change its meaning or change its text, which is exactly what they tried to do. So this was a pretty dodgy time, and this is when an enormous amount of damage was done to the Constitution around that sort of time. So download that essay, get into that, because it's really quite surprising and quite interesting. So carrying on with other aspects then, as already mentioned, the gradual shift from a convener, an administrator of the court, to a full judge as an employee of the state, thus usurping the preeminence of the juror as the supreme judge, was another method of subverting the constitution. So we sort of talked about that, haven't we? That essentially, and related to this is the next point. Okay, so let's just go straight on. Related to this was the gradual taking of the rights of the jury to judge various aspects of the case. Under authentic common law, it is the right of the jury to judge all aspects, including the facts, the law, the admissibility of evidence, motive, criminal intent, and the sentence. This has gradually and unlawfully been clawed back by the state judge over time. Right, so those last 2 points are kind of related. So it's to do with the power of the convener, who was really only there to run the proceedings, has now become the state judge, with supposedly authority over the jury, which is not true. They don't have that authority, but they now try to direct a jury, which is absolutely unconstitutional. And as we're saying there, the jury has the right to judge on all aspects of the case. And that's important because if you think about it, if it's a court of conscience, you can't really divorce any of those aspects from it. If you're applying your conscience to these things, then all of those things in the round are absolutely critical, and it couldn't possibly work any other way. And then one last section here. Under authentic common law, the principle of unanimity is crucial, in which all jurors must return a guilty decision if the accused is to be found guilty. The modern concept of a majority verdict is a distortion of authentic common law. Okay, so there are a number of important things there that it's just worth absolutely clarifying there in that appendix. But that brings us to the end of the document, The Occulted Powers of the British Constitution, which was really meant to be the framework of those videos. But I just want to go on and discuss one or two other things, put a bit of context underneath some aspects of it, talk around some bits and just summarise some things as well. And as we're not using the document, what we might do is actually make that video bigger, which might be quite frightening for you. So I've got a few notes here. Let's just go through these things. So the first thing I wanted to say, just to clarify, was this business about the purpose of the Constitution, going back to that. The purpose of a Constitution is that really the most dangerous threats, if you like, to a population, to a citizenry of a country, is and has always proved in history to be its own government. So you can look at almost the history of any nation, and you can prove to yourself that the most dangerous threat to any population is their own government, not really an external threat so much. And the reason for that is because the most dangerous thing is those that undermine and subvert from within. Yeah. And that's got to be the nastiest thing that any of us could face, is a sort of treacherous treason from internally within our nation or within our community. So that's the purpose of a constitution, is to guard against that. But constitutions can either do that successfully or they don't particularly do it very successfully. And whether they do or don't hinges on that one particular thing, which is there a mechanism in play that successfully subjugates the government, that places the people in authority over their own government at all times. Yeah. So we've already talked about that earlier in the series, about what we think of as democracy wrongly, which is this idea that, well, we get to have an influence over our government as the population simply by voting parties into office. And I think we all know that adult suffrage, which is what it actually is, doesn't really work. That's not the people ruling, which is what democracy is. If you look at the etymology of the word democracy, it really talks about the people in rulership over their nation. And true democracy, therefore, requires something where the people can actually do that properly. And the only mechanism that anyone has ever come up with is trial by jury or some kind of natural law tribunal. Okay, and what that means is that the government's own legislation sits under the authority of the people every single day all over the country. Yeah. So if your constitution has that feature within it, and a democratic common law constitution does, then it's worth having. That's the whole point of a working constitution, is that it's supposed to have that central pillar. And if you don't talk about trial by jury, full jury independence, the authentic common law version of trial by jury, then you're kind of missing the point. You're not really understanding what is the purpose of the Constitution. Okay, so that's the first thing I wanted to mention. The second thing is that I just want to clarify this business to do with the contract. Some people claim that that the Constitution is a contract with the people. No, it's not. It is a contract. It's a one-sided contract, but it's not a contract involving the people as a bound party within that arrangement. The people are absolutely left alone under their natural state, with their inalienable rights, their natural rights under universal law, under natural law, and then the existence of government, which is an artificial idea, isn't it, if you think about it, is all about constraining them and limiting them so that their only role can be to prop up and help the people live under their natural rights, and to do that justly and fairly, right? That's the purpose of government. It's actually to assist and to uphold those principles. That's really what it's for, nothing else. And so the principle is that if they go outside those boundaries, if they go outside those limitations, then in effect what they're doing is delegitimizing themselves as a government. The government delegitimizes itself if it steps outside those constraints. It's quite a simple principle, really, isn't it? Yeah. So it's not a contract with the people, and the reason why, if you think about it, is that you couldn't possibly get the people to sign. How can you do that? First of all, the people is a collective. It's a group. You can't get the people to sign into a contract and be a party to that. And nor could you in 1215 go around the country getting every single person in the country to sign into that contract. Can't do that either. And of course, the third thing that you can't do is that you can't bind future people who haven't yet even been born, future generations, into a man-made construct, because that in itself is breaching their free will and is working against natural law. So that would, if that were the case, then it would be an unlawful constitution. It just wouldn't be allowed. So in order for it to function in alignment with natural law and in alignment with natural justice, the Constitution has to be leaving the people in a natural state, whilst it binds government only into upholding and supporting the already existing natural rights of the people. That's really important. So that was the second thing. And the third thing I wanted to address was once you actually think through completely and think of all the implications of what this means in reality, what it means is that the people are living an anarchist-like lifestyle, essentially. Now, for that reason, so what we're really meaning by that is an individualist ideology and almost full-blown anarchy, but it's not actually. In fact, it's short of full-blown anarchy. So what would that be? Full-blown anarchy would be, yes, self-mastery, but because we are imperfect as human beings, it means that full-blown anarchy is dangerous because you would be effectively taking the law into your own hands. Yeah, you can't do that, right? So you need an anarchist-like lifestyle, but what the limits are essentially that you submit to the consciences of the people in your community. So when something goes wrong and it seems as though that there is concern in your community about whether you've committed a crime, it's at that point that you have to submit to the consciences of the people around you, as you would do naturally in any human relationship. If you're living in a village in in some part of the world in the middle of the Amazon jungle or something like that, it's the same principles apply. You don't live in that community, in that community, and then do something that would hurt other people in that village and then think you're going to get away with it. It's just not going to happen. Okay, so naturally we will submit to the consciences of the people around us, and it's doing that causes us not to be living in a full-blown anarchic system. It's anarchy with limits. It's anarchy with a safe container. And that's really what democracy is. That's why it's gold, right? Because it's anarchist-like, but with the safety mechanism in place because of our imperfections as human beings. Really important, that. So that was the third thing. And then, just the last thing to say on that, which leads me into the fourth point, which is that anarchists really need to jump on board and understand the value of this, because they have a tendency to think that whenever anybody starts talking about the Constitution, they immediately think, oh, you're talking about government, you're talking about the state. Well, no, because actually understand the important point that under this constitutional mechanism, we don't really have a state in the true sense, because you don't have a government with any kind of teeth or power. Okay, when it's the people doing their own governing and the government is simply carrying out the wishes of the people, then you kind of don't really have a state in a sense, right? And that means that anarchists should be looking at this and taking it seriously. And I'm getting a bit frustrated because I like anarchists a lot. I have a lot of time because I kind of am one, really. Anarchists like, people like Mark Passio and Larkin Rose, I have the greatest respect for these people. I've learnt a lot from them. But actually, this is a blind spot for them. They still haven't spotted this. And I think that anarchists would do well to take a hard look at this and realise that this ultimately is really what they're after. All along, this has been the thing that's hiding, in the middle of all these different things that people, these different groups that people sit in. It's this little thing in the middle called our Constitution, which actually is going, I think I've done this. I've already achieved this for you, by the way. And that's the trick, I think. Somewhere along the way is we've got people of the establishment over here. They don't like what I'm saying about the Constitution. They don't like the authentic version of the Constitution because it frightens them, because they're in a collectivist mindset, so they don't like the idea of the people governing themselves. That's scary, right? And I can understand that, because what that potentially means is that we've got risk and we've got danger to get back to where we should be. It's all about taking responsibility, and I understand. But we got the freedom movement as well that don't like it, because they seem to think that it's all about administrative fraud and things like that. Well, no, it's not really. It's actually about this. It's about a contortion in the ideology of how law is affected by a kind of distorted ideology in the establishment, essentially. So that's what it's really about, and they don't like it because it sounds old-fashioned and kind of government type thing, and it's all establishment and the political class and that sort of thing. But they don't realise that the Constitution actually has the seeds of that brilliance within it. So they don't like it either. And as I've said, anarchists don't like it either. So I'm increasingly finding that this constitutional law material is kind of sitting somewhere in the centre, in a sort of space that people are just looking over. They're not spotting it at all. And I think if people really sat up and listened and really read into this, they would realise this is what we're all after. It always has been, in fact. So that's it. I hope you found this series useful, and I hope it clarified some things for you. A little bit of a rant at the end. Hope you didn't mind that. But the deeper material that underpins the Constitution, so we're going to go into things like natural law, human psyche, the mystery traditions, explaining about the ideology that supports the Constitution. What kind of an ideology in society does broadly do people have to have? individual rights, essentially, individualism. All of that is explained more on the Law and Alchemy website, whereas common law constitution is going to be more and more focusing purely on the mechanics of the constitution and law. So hope that's useful, and thanks for listening. Cheers for now.